Dear students, now this is your second video regarding kinds of contract. In this video, you will get information about the other two classifications of contract. The second classification, as you know, that is according to the formation. In according to formation, the first classification, you can say sub-classification, is express contract, and second one is implied contract. After the implied contract, here comes third subclassification, which is called quasi-contract. Taking you back to the first subclassification according to the formation, that is express contract. As it is clear from the name, express means when parties are going to establish a contract orally or in writing. That contract is called express contract. Let me read few lines for you. A promise made in words is called an express promise. Express promise result in express contract. Parties directly state the terms of contract. So, simply speaking, a contract which is established by the party either orally or in writing, that is called express contract, where the parties clearly express the terms and conditions of the contract, that is called express contract. Next to the express contract, implied contract. It's another different type of contract where you will not see the terms of the contract orally or in writing or in a written way or in a oral way stated by the parties. These are very unique types of contract. Let me read out the statement of implied contract. Proposal or acceptance is made otherwise than in oral words. So you can see no oral or written words are involved in that specific type of contract. An implied promise result in implied contract. Such contract arises from acts, conduct, course of dealing, and circumstances. So you noticed there are certain types of acts of the parties, or you can say due to the conduct of the parties or course of dealing of parties or circumstances establish such types of contract named implied contracts. Here are few examples. You can see a few glimpses. On your screen left hand side, a picture of a railway station, railway platform you can see. In the middle you can see a picture of a shoe shiner boy, and on the right hand side a picture of a restaurant. When you are on a railway station, a coolie came to you, and that coolie picked up your luggage and you allowed him to do so. Your conduct is allowed him to do so without speaking. Why you are going to pick up my luggage? And the coolie's act is picking up your luggage without asking you, without requesting for picking up. So both parties are acting. This act is going to constitute a contract between coolie and you. So this is a very simple or easy example of implied contract. So is the case with the shoe shiner boy. When shoe shiner boy picks up your shoes for shining purposes and you allowed him to do so without asking any words from the shoe shiner or from your side, is an example of implied contract. Next comes a quasi-contract. Once again I tell you, dear students, it's a very you can say interesting type of contract. Rights and obligations do not arise as a result of an agreement. Law imposes certain obligation under special circumstances. So here, law is going to impose certain obligations on the parties. When law is going to impose, a big question is here. This contract is based upon the principle of equity. It is not a contract but creates relations similar to the contract. Law recognizes such relations as a contract. It is also called as constructive contract. Now you can see on your screen a bag on a parking bench. Now, if you trespass this bench on which bag is there, or you can say bag is lying there, and you didn't notice that bag, you will not be called as finder of this lost purse. But if you pay attention this bag and pick up that bag, you will be called as finder of the lost purse. After picking up the bag, a contract has been established. The law imposes certain obligation on you. You become the finder of the lost purse. And being the finder, your obligation is to find the real owner of this purse. So the law imposes obligation on you, and a contract has been established between you and the owner of this lost purse. Next category or classification of contract, that is according to performance. The first one is executed contract and second one is executory contract. Executed contract means which is done. In easy way to understand, you can say when both parties have performed their respective parts of promises, or you can say nothing left to perform. In normal circumstances, in normal situations, when both parties have performed their obligations, have fulfilled their obligations, and nothing is left to perform on their respective parts, it is called executed contracts. Next to the executed contract, there is executory contract. Executory are of two types, but before going into the detail of those subkinds, what executory contract means remains to be done, means something left to perform. When both parties have yet to perform their obligations, it becomes executory contract. Executory contracts further are of two types. First one is unilateral and second one is bilateral. In unilateral contract, one party makes a commitment to perform his part of promise. One party in this case is bound, but other party chooses to bound by it. Next, bilateral contract. Both parties are bound by it, means both parties have yet to perform their obligations. So this is all about, dear students, from the very important question which is named kinds or classification of contracts. If you want to have further latest information from the book of business law, stay tuned. Good luck. Allah Hafiz.